Hey guys, I'm Puyan Darian, an immigration lawyer, and I do weekly immigration subject videos. And this video is going to be about a question that one of my subscribers asked me to answer in a video. If you finish the video and you have your own immigration questions, put them in the comments below, and I might make a video about it in the future. At the very least, I'll try my best to answer your question if you ask it within a few weeks of the video posting. So the specific question was, I have an unlawful entry, and if an alien is present in the US who has not been admitted or paroled and has applied for asylum, but the asylum case gets dismissed by a judge, then what happens next if that immigrant marries a US citizen and applies for an I-130, which is a family petition, and an I-485, which is currently pending? So he asks, what happens next? And so this situation is about somebody who was in removal proceedings. They had an active immigration case. The case gets dismissed, and then he files a family petition, presumably based on marriage to a US citizen, and has now applied for a green card. Can this work? What happens next? What does it mean to get your case dismissed by an immigration judge? These are the topics we're going to be discussing in today's video. So the first thing is, how do you get your case dismissed if you are in removal proceedings? Well, it's very fact specific, and in a few years, this might not be true. It's based on current policy guidelines for the Department of Homeland Security. Currently, in the middle of 2023, if you entered the US more than 1 year ago, and you have some favorable characteristics or positive equities, for example, you have US citizen family members, or you've filed tax returns in the United States, there's a possibility, at least in the New York immigration courts, of getting your case dismissed. That means you won't have status, most likely, but you're also not getting actively deported, and you don't have to continue to attend deportation proceedings, and you won't get a removal order, a deportation order from the United States, which is almost always a good thing. Generally, you're left in some sort of limbo where in the future, if there's an option available, such as marriage to a US citizen, you might be able to fix your immigration status. So the question asks whether you can apply for a green card if you've entered the US without being admitted or paroled. But let's take a step back. The first thing this guy did was file a family petition based on, I believe, marriage to a US citizen, which is a great thing. That is the first move to make. But if you haven't been admitted or paroled and you don't qualify for some other exception, which is like Section 245I of the Immigration Act, which most people who've entered after 2001 will not qualify for, a pending green card application based on a family petition is most likely going to get denied. It was the right move to first file the family petition, but he currently has a pending green card application, and that is most likely going to get denied unless he was able to fix his illegal entry. I've done videos on different ways to fix illegal entries, such as military parole in place, and other forms of parole, but that doesn't appear to be the case in this situation. So the green card application is going to get denied. But let's talk about some other situations here. Let's say that he entered and at the border or in the airport, immigration paroled him into the United States. Or let's say he entered on some sort of visa, like a tourist visa, and then he was placed in removal proceedings, and then the case got dismissed. The problem here is his illegal entry. If he didn't have an illegal entry, he would qualify to apply for Form I-485, adjustment of status. But since he cannot prove that he was ever inspected or paroled, the I-485 will most likely get denied. And that's the key here. So now, if you're in this situation, what are your options? Well, like I said, the first step is file the I-130 and get it approved, like my subscriber did. He has an approved I-130. Now, most likely he's going to need an unlawful presence waiver because he's going to have to leave the United States to go for a consular interview abroad, presumably in his home country, but since he applied for asylum there, he might need to go into another country for the interview process. But the problem is he has unlawful presence in the United States now. And if you have more than 180 days of unlawful presence and you leave the United States, you will trigger an unlawful presence bar. He won't be allowed to re-enter the United States for years. So the next step is from within the United States, apply for an unlawful presence waiver. So if he does eventually leave for a consular interview, he won't be barred from re-entering the United States. Remember, the bar gets triggered the moment he leaves the United States, and then he's stuck outside of the United States for anywhere from 3 to 10 years. So right now, I would file an I-601 unlawful presence waiver. This may or may not be available, so you need a permanent resident or US citizen spouse or parent to apply for this type of waiver. And you need to show that if you're unable to return to the US, this qualifying family member will suffer hardship. And it needs to be serious hardship. More difficulty than a normal spouse or parent would experience from being separated from you. So not everyone will qualify or have the evidence necessary. But the good news is, even if your application gets denied, you can apply multiple times. There's no limit to the number of times you can apply for an unlawful presence waiver. And currently, at the time I'm making this video, it takes more than 26 months for this type of waiver to get processed. Let's say that he applies for the I-601 unlawful presence waiver and it gets approved. At that point, we can proceed with the consular process. We can schedule an interview in a consulate, and then he would leave for presumably just a few weeks to attend his medical interview in that consulate, attend his interview, and then re-enter the US as a permanent resident if all goes well. Now, one thing to keep in mind is once you leave the US, some of these consulates are kind of like the Wild West. There are laws and regulations that they're supposed to follow, but if they make a negative decision, an adverse decision, and they say like, oh, well, actually, we're going to deny your case because we see you committed this crime and now you need a crime waiver as well, you're going to be stuck outside of the US for a long period of time. I've even seen some consulates say like, oh, well, when you entered the United States, you entered with your children, and that qualifies as alien smuggling. So you're not allowed to apply right now. You're going to need another waiver for that. And it could take us a year to process that while you're separated from your family waiting in your country of origin. So be sure to speak with an immigration lawyer before you ever actually leave the United States for one of these consular interviews to make sure that everything is correct and you have all of the waivers necessary to be able to come back into the US as fast as possible. I want to thank my subscriber for asking this question because my focus in my immigration office is on family-based green card applications and deportation defense cases. So this was the perfect combination of the two in a very well-worded question. If you take anything away from this video, it should be that immigration law is really complicated and there are 1,000,001 ways your case can get denied in a system that's so complicated that an entire field of law is dedicated to it. So if you ever need assistance with your immigration case, please feel free to schedule a consultation. You can book it directly through my website or call or text us. And also, if you're new to my channel, I put out a new video every week. Be sure to like and subscribe, and I'll see you guys next week for another video.